Well, of course, we all know that we are preparing to vote in a huge election. We're going to be electing all sorts of folks, and not just the President of the United States, Congress, state legislators, etc. But a fascinating new book written by our guest today takes a look at the unelected. In fact, the title of Jim Copland's book is The Unelected: How an Unaccountable Elite is Governing America. And I've had a chance to read parts of this book, and I'll tell you, it's really amazing. So glad he's along to talk about it today. Jim Copland is a senior fellow at the Manhattan Institute, where he's also director of legal policy, and you have read his work all over national media. You've seen him on television, you've heard him on radio. And by the way, he holds a JD and an MBA from Yale, where he was an Olin Fellow in Law and Economics. He also holds a BA in Economics from none other than UNC Chapel Hill, where he was a Moorhead Scholar. Jim, so glad to have you with us here for our Shaftesbury Society. Thank you for joining us.
Thank you for having me, Donna, and it's always a pleasure to speak to the good folks at the John Locke Foundation. I've said it before, as someone who works and has worked for many years now at a national think tank. So much policy happens on the state level, and John Locke Foundation really is a gold standard state think tank that has really helped reshape North Carolina in such a positive direction. And a lot of the strength, resilience right now, and fiscal, being on sound fiscal footing in the midst of a pandemic is really due to the great work that the John Locke Foundation's done. So thanks for having me.
Oh, well, thank you for those comments. I really appreciate that. And by the way, people should know that you actually live in North Carolina. So your book writes about federal policy, but you're following state public policy as well. And hopefully, after we talk about your book a bit, we're going to get your take on what's happening with Governor Roy Cooper and the use of emergency powers, et cetera, here in North Carolina. But Jim, I got to tell you, this book, The Unelected, again, you can buy this book now, and I think my colleague Brene is going to be posting in the comments section of our Facebook page where you can actually get your copy of The Unelected. Jim, tell us about the key themes from your book and why you wrote it.
Well, the key theme really is that people don't understand just how much government activity that oversees our lives, and in some of the stories we'll talk about later in the book, tragically has influenced the lives of some people, and in other cases just given significant headaches. But how much of that apparatus goes forward no matter how we vote? Now that doesn't mean that elections don't matter. I mean, who's president matters, who's in the Congress matters. Here at the state level, the governor, the council of state, the General Assembly matter, and here we elect judges and justices, and they really matter a lot too. So it's not that the elections don't matter, but they only capture an incomplete picture. There are a couple million federal employees. There are 50 states. There's thousands of municipalities. There's well over 1 million private lawyers that influence us through the litigation system. And so all of these different pieces, I mean, we've heard attacks, some of the partisan attacks on the deep state and these sorts of things. And I try to stay away from that sort of partisan view and really just look at it more telescopically and thematically and look at, you know, what the government's doing that really departs from our fundamental constitutional design. And so, I mean, the Constitution and clearly had its flaws in the beginning, most notably the countenancing of slavery, but the Constitution really had two animating principles. There was a notion of limiting the government to prevent abuse, and this is a notion that dates back to John Locke, among others, and then the notion of having a publicly accountable government that was in some ways active and could get things done, but was ultimately accountable to the people. And these sort of representative democratic principles, as well as the sort of limited government, classical liberal principles, both animated that constitutional design. And those two principles have been substantially eroded. I mean, it's hardly a surprise to anyone to look at the incredible growth of government. I mean, I talk about it sort of in my final epilogue here, just the growth and size of some of the government, or actually, I guess it's chapter 14, Restoring Republic, looking at how much the government has actually grown from those early years where even adjusted for inflation, I mean, the first Congress, the total appropriations of the federal budget was only $639,000. Even adjusted for inflation, that's $10 million. Right now, the Congress can't agree on the next level of COVID relief, but the gap is between 1 trillion on the R side and 3 trillion on the D side, just orders of magnitude more government than we had in the early years. And a lot of people have written about this, and I tend to agree with the limited government types. I mean, I've worked in a think tank like John Locke that's committed to individual liberty and free markets and personal responsibility in these sorts of questions, and skeptical of big government generally. Although, as I note in my book, there's some caveats to that where it makes sense for us to depart from the original constitutional design. But what a lot of people haven't paid as much attention to, and certainly not thematically and holistically, is the concept that we've lost some of this public accountability. And the sorts of work that I've done over my many years in the think tank world have sort of dovetailed along all these issues. So working on things like tort reform in the civil litigation system, looking at the administrative state and regulation, looking at overcriminalization, something that I've worked on with your legal scholars, John Guzet and others at the John Locke Foundation in North Carolina and in other states, and corporate governance, securities law, things like this. They all sort of come back to this central point where we see a lot of government being done and a lot of liberty being lost from individuals who are acting without public accountability. And in many cases, we see significant radical shifts in the legal and regulatory structure that govern our lives without Congress ever taking a vote, without the people we've actually elected deciding to do so. And so that's the principal thesis of the book. And I sort of break it down into 4 different sort of categories that are interrelated, but I think important to understand that each of these forces matter, and we might reform one of them, and it wouldn't necessarily change as much as we might think if we're not cognizant of the fact that all these other sort of players are similarly working to govern us without any sort of public accountability. And so the first of these are what I call the rulemakers, and this is really the fundamental function of Congress. All of us who grew up when I did, basically anyone who grew up in the 70s, 80s, and 90s, if they watched ABC Saturday morning and saw the cartoon shows, they would see Schoolhouse Rock, educational cartoons, and among those, one of my favorites was I'm Just a Bill. I'm just a bill. Yes, I'm only a bill. Sitting here on Capitol Hill, and that still describes how a bill becomes a law, but it misses a lot of the way that rules actually get enacted. So in the criminal law sphere, for instance, we don't know for sure how many federal crimes there are. It's just too voluminous for us to even know. But the estimate is around 300,000 federal crimes exist. Of those, 98% came into being without an express enactment by Congress. So in other words, what Congress did was create a rulemaking agency somewhere in the executive branch, and they drafted the rules, and Congress never saw those rules again. And those rules can lead people to go to prison, to get in trouble. These have real teeth, criminal teeth. And of course, the same thing's true across the civil law. So this is quite a departure from the principle espoused by Locke, among others, that sort of animated the Constitution, that the lawmakers had to make the laws. They couldn't delegate the lawmaking and make new lawmakers. But that's in fact what we've done through the growth of the administrative state. And most of this has been done over the last 90 years or so, really beginning in the New Deal. There were precursors in the Progressive era, some late 19th century precursors. But by and large, we've seen a sea change in this, and certainly an expansion of this delegation of rulemaking during the last 90 years or so. And it continues to accelerate. So, I mean, we see it. Both parties are guilty of this. Both parties do it just recently, the Trump administration Centers for Disease Control came out and essentially said they're abrogating private mortgage contracts across the entire country. Now, there's certainly a policy case to be made saying we don't want to evict a bunch of people in the middle of a pandemic. But normally this would be the sort of thing Congress would have to come to an agreement on, not something that you'd have an agency, and this is not an independent agency, it's an agency that reports to the president, but an agency sort of coming out unilaterally with this sort of rule. There are multiple sort of constitutional questions to be raised by that action, but clearly what we have is something far removed from a bill becoming a law as it's portrayed in Schoolhouse Rock. The second sort of force, or the second sort of unelected actors that I focus on in the book are what I call the enforcers. And this is really important to keep in mind, because if we make it too hard, if we to actually create new rules and aren't paying attention to enforcement actions from the executive branch, then we can get something that's in some ways more lawless than just regulatory rulemaking itself. And that is sort of this ad hoc government by the threat of force. And so when talking about it from big businesses, I sort of compare it to The Godfather. You know, this is an offer you can't refuse. Because if you're a big business dealing with the federal government, often they have your business totally under their control in the following respect. I mean, if you are a military contractor, obviously, if the federal government says you can't sell to the military anymore, then you're out of business. If you're a pharmaceutical company and the federal government says you can't get reimbursed through Medicare and Medicaid anymore, you can't do business. If you're a financial company and the federal government says, you lose your license to practice in these financial markets, you're out of business. And so really the strong arm of the federal government is often coming into play. The problem, though, is not just a big business one. I want to emphasize this. In fact, it's a much bigger problem in some respects for the small business owners, the family farmers, the individuals, because the big businesses, remember, they have large compliance teams. They have a bunch of lawyers with fancy degrees studying these rules and regulations and trying to keep the business out of trouble. It doesn't mean they're going to be able to comply perfectly. It does mean that the government's able to strong arm them and create regulations far beyond what was ever authorized as an actual sanction for conduct by congressional statute. But they at least can try to comply. If you're a small business owner without a team of lawyers at your disposal, how are you supposed to comply with 300,000 federal regulatory crimes? There's just no way. And this also happens very much on the state level, which is why we did a report and have worked in close concert with the John Locke Foundation on this, in talking about overcriminalizing the states. And some of these same principles that I talk about with the federal governments also exist on the state level. Now, the enforcement is a little different, and the resources for enforcement are a little different. And certainly it's the federal level usually where we see strong arming of big businesses through regulatory enforcement, although not exclusively. And certainly in New York, our state AGs have done a lot to sort of strong arm entire industries and remake those industries sometimes with really bad consequences that I can talk about. And so that's the sort of the rulemakers and enforcers are the sort of what we talk about the regulatory state or the administrative state. These are people, they're not publicly accountable. Now, at some level, high-level folks do go through an appointment and confirmation process. It's not like they're free radicals with no connection whatsoever to the elections we hold. But there's a lot of civil service employees underneath, and there's a lot of autonomy. And essentially, we're end running the sort of checks and balances that the founding fathers put into the Constitution, that the early states and the subsequent states joining the Republic agreed to try to slow down various legislative and regulatory moves. Now we've sort of end run around that with this regulatory state.
And Jim, let me ask you this about the rulemakers and the enforcers.
Yes.
Is this really what some people refer to, at least recently, as permanent Washington? The people who are there, no matter the administration, no matter the politics, but behind the scenes wielding all sorts of power?
That's basically correct. Yes. I mean, I don't want to overemphasize that to the extent that a number of the federal agency apparatus is very much responsive to the presidential election cycle. But that's part of the problem. In other words, we put so much stock in presidential elections precisely because the presidential executive branch has so much authority. And of course, the same thing's true with the judiciary. I mean, 21% of the people in the last election told exit pollsters, well, federal judicial appointments was my number one reason for voting for president. This would have shocked the founding fathers. Not that they didn't believe in judicial review by and large, and not that they didn't think judges were important. It would have shocked them that it was the number one issue in electing a president. So there is a lot of power that comes into play, but it can be slowed down, and the courts sometimes adopt a one step forward, two steps back approach to reviewing this. I mean, in the last administration, of course, Barack Obama, after not being able to persuade Congress to do what he wanted with unauthorized immigrants who'd come here as children, unilaterally did this through executive action. The Trump administration came in and tried to reverse it, but the court said you didn't do it right. And so now that unilateral executive action has taken on a life of its own. In other cases, we have seen reversals from administration to administration, but they can be reversed right back with another new election. So there's not a lot of permanency. There's not a lot of stability in the law. And by and large, the review apparatus that the courts have brought to bear on the administrative state tends to give a hard look, a close look to to reversals of regulatory actions. So there's a lot of deference given in the first instance to writing new regulations. And then when a new administration comes in and tries to undo those regulations, it's often harder for them to undo the old regulations than it was to do the new regulations in the first place. And so I think this gets it kind of exactly backwards, but that's the review system that we have right now in the courts. So
essentially you're saying it really does matter who you elect for president, and based on that person's view of the regulatory state and all that, even though it can go back and forth with these executive orders, but it does matter.
It does matter, although not all of the federal government is as responsive to the executive. So chapter 2 of my book sort of goes through this principle where we talk about these independent agencies. And essentially, the courts have allowed independent agencies with sort of these quasi-legislative powers and staggered terms of rulemakers. So things like the Federal Communications Commission or the Securities and Exchange Commission. While there are presidential appointments in play, they're bipartisan commissions. So the minority party, in this case, it's the party that doesn't control the White House, gets the minority of the seats, and they're staggered terms. Now, there are defenses of this. It creates a little bit more continuity. You don't get these policy reversals through independent agency structures, but it's very, very different from the basic constitutional design we all learned about in grade school. And these sorts of bodies wield, again, substantial power. It's delegated by Congress, but Congress delegates it broadly. And the White House can't come in here and say, I want this person off the Securities and Exchange Commission. I don't like their views. The White House does not have that power. The elected president doesn't have that power. So all of these folks, I mean, while they're unelected and the big problem here is you often get true believers, at least for those of us who think the government can get too big. So you get folks who are committed to environmental reform, or you get folks that are committed to a certain view of securities law. You get folks that man the agencies, that populate these agencies, that have a certain view of the world. And most of the civil servants underneath the top elected officials tend to skew in a certain direction, and they tend to have a pro-regulatory skew. It's rare that you're going to get the sort of deregulatory champion to want to devote a career to being in the regulatory agency, right? So you have this sort of problem. But then we have in this country, and every country has a legal system. A legal system has to adjudicate disputes. We have a private legal system as well as what we call a public legal system. So when we talk about criminal law, that's the state prosecuting misconduct, and that's of course something under a lot of scrutiny right now. And then we have the civil law, which is private parties bringing their disputes to the government to resolve, be they disputes over property, be they disputes over contracts, or be they disputes over what lawyers call tort, which is sort of accident law, injury law, where it's not necessarily predicated on a pre-existing contractual relationship, although a lot of cases that would have once been contractual now sort of fall under tort. So the products we buy, there is a contractual relationship of a sort. There's a sale that goes into place. You voluntarily buy it, but a lot of these tort law rules govern those sorts of lawsuits.
Is this where the class action lawsuit comes in, Jim?
Well, a class action lawsuit is a variant of the ordinary sort of tort lawsuit, and it's a relatively recent creation. And this is sort of the third part of the book talks about the litigators, and this is what the litigators mean. It means these folks who are litigating private disputes, and a lot of folks, I think, reflexively, who are skeptical of government power, libertarian-oriented folks, classical liberals, say, oh, well, this is much better than the administrative state. Sometimes it is, and sometimes it isn't. But make no mistake, I mean, this is still state action. So it is nobody is a defendant in court by choice. Someone is a defendant in court because another person sues him or her, sues the business, and it's only the state's monopoly on force that enables the plaintiff to recover. Now, if the legal system works well and was a low-cost way to resolve disputes, and sort of we just made it basically about accidents, that would be one thing. And what's important to realize is while this is deeply rooted, the jury trial itself is rooted in our federal constitution, most of our state constitutions, but in the original conception here, it was a very, very narrow area of law that could sort of sue for these damages for accidents. Very difficult to get into court, very particularized pleadings. In the early days, neither the defendant nor the plaintiff could even testify in court for these sorts of cases. If you assumed any sort of risk, you weren't going to collect. If you were negligent at all yourself, you weren't going to collect. And all these rules sort of got scaled back over time. And then we sort of had developed the modern sort of plaintiff's bar through the use of fee mechanisms. So virtually every other country in the world, certainly the European countries, and other than some Asian exceptions, if you bring a lawsuit in court and you lose, you have to reimburse the other side's fees. But that's not the way our system works. So you get, in fact, if you defend your lawsuit successfully, you can still lose. And so the first example I use in chapter 7 here is of a woman, Kathy Reese McNeil, who wanted to renovate a historic hotel out in California. Movie stars had stayed there, et cetera, put a lot of money into it, let a friend of a friend stay there, and then that individual got a plaintiff's lawyer to file a disability lawsuit. Well, of course, she hadn't gotten everything up to disability code yet. She was still renovating the hotel, but it was basically one of these sort of shakedown lawsuits. Give us $18,000 and we'll go away. And she said, I haven't done anything wrong. I'm going to fight. Well, she won her case, but then she lost more than $100,000 winning her case, which is why you get these shakedown lawsuits in the first place. So class actions is a piece of that. And that's really where you can sort of add a bunch of cases together. And one of the most famous securities class action attorneys, Bill LaRock, said, I have the best law practice in the world. I don't have any clients. Now, he's not a member of the bar anymore. He went to federal prison to be his clients. But that's kind of how it works. So the lawyer files the lawsuit with a titular named plaintiff. Every person in the class, it could be thousands or millions in the case, but it tends to be a very small interest in the case. So no one's really monitoring these attorneys, and it's really the attorneys on one side suing the business and reaching a settlement, and they virtually always settle because of the stakes. And this was quite recently invented in the 1960s. The federal rules were first created, the federal procedural rules for litigation came in their modern genesis, gave it to the Supreme Court, and the Supreme Court gave it to a committee led by law professors. So the dean of the Yale Law School developed all the new rules. This idiosyncratic thing in the United States where someone files suit without any proof, and then you have to turn over all your emails and sit down for depositions. That's an American rule and an American invention, really without precedent, from the 1930s. And then in the 1960s, they kept this committee around. This time it was run by a Harvard law professor and his young protege from Columbia. And they literally crafted the modern class action rule where you're in the class as a plaintiff unless you affirmatively opt out. So the lawyers create the class. They may send you something in the mail. They may post it on the internet. And if you don't say, keep me out, you're in. They created it on the back of the professor's car riding the ferry over to Martha's Vineyard on a manual typewriter. I mean, this is how they developed this. It never existed before. These law professors drafted it. And so we have these sorts of crazy sort of shakedown class action suits. I mean, listen, there's a defense for a class action rule, but the rules tend to be skewed on behalf of those bringing the state power to bear. So that's the sort of third layer of, in addition to rulemakers and enforcers of sort of the unelected. And then briefly, and I've run over time, but we've sort of gone back and forth a little bit. We have what I call the new Anti-Federalists. And this is an important one too, because most of us who support limited government and sort of classical liberal principles instinctively say we're pro states' rights or we're against the big federal government and we want to devolve things down to the state. In the ordinary case, that is good. State legislators have every incentive to get the policy package right at their state because people can vote with their feet. And businesses and capital can vote as well and move from one state to the other. So if California raises its taxes or New York raises its taxes and North Carolina doesn't, businesses and people can move from California and New York to North Carolina. If the regulatory state in one state is too big, same thing. And similarly, it's not just a minimalist pressure here. If a state doesn't provide good services, if its roads are falling apart, if its schools are horrible or what have you, that's going to affect where businesses and people locate as well. So it creates this sort of implicit market style pressure through federalism forces. But that doesn't always work. And so in litigation, it's sort of a classic case where it doesn't always work. If you're just talking about a slip and fall case for your local business, well, sure, if your business is getting sued by its workers or its customers locally, and the state is too permissive for the plaintiff's lawyers, then businesses will be less likely to open. And the same thing with some of the medical malpractice suits. Similar sort of federalist pressures at play. If doctors get sued a lot, doctors can relocate to other states, and hospitals can invest elsewhere rather than in your state, et cetera. So you'll ultimately pay the price for that. But we do have these situations where a national commercial lawsuit can be filed anywhere under the current doctrine that the courts adopted, as long as it's in the stream of commerce. So North Carolina can attract a business based on its tax and regulatory regime, but it can't protect against a lawsuit coming from Madison County, Illinois, or one of the other places that the American Tort Reform Association calls judicial hellholes, and you're going to get sued there. And then what we've also sort of seen with this new anti-federalism are these elected officials, but they're local or state elected officials basically dictating policy for everyone else. So the mayor of New York coming out and trying to change climate change policy, which is clearly an international question with a federal nexus, but trying to do it from the city hall in New York or in San Francisco. We see these sorts of cases. We saw this with the tobacco lawsuits sort of first, where the litigation gets farmed out to plaintiffs' attorneys on behalf of the state attorneys general, who often get a lot of campaign contributions back from the plaintiffs' lawyers that they turn around and hire. And so we see this sort of national policy being driven by state and local officials. And nobody in Raleigh or Charlotte or Greensboro voted for the people in New York City and San Francisco or in Albany and Sacramento. And yet these elected officials from other states are trying to drive national policy. So I call this sort of the new anti-federalism. It interferes with the federal scheme. And even when the federal regulators get it right, the state actors can come in here and try to dictate national commercial regulation from their state and local purchase.
Pretty amazing. We've been talking with Jim Copeland here of the Manhattan Institute about the 4 key areas that he reviews in his new book. It's called The Unelected, How an Unaccountable Elite is Governing America. And again, if you go to the comments section of our Facebook page here at the John Locke Foundation, you can find a link where you can actually get Jim's book. So there's so much here to talk about, but I really want to get back to something you mentioned early on in our conversation, Jim. You brought up the CDC. And of course, right now with COVID-19, we're paying close attention to the CDC and their scientists and experts, much more than I would suspect any of us ever paid attention to the CDC before COVID-19. But talk about the power. In fact, John McCormick over at National Review just a few days ago wrote a piece, the headline, "The CDC's Power Grab." And I think one question here is really relevant to what you're talking about in your book. If the executive branch can unilaterally suspend residential evictions to limit the spread of coronavirus, is there anything it can't do? So Jim, with this administrative state, what can't the administrative state do?
Well, I mean, there are still some guardrails around what Congress can do, but it's an extremely broad power. Basically, under the auspices of the Commerce Clause regulating interstate commerce, the courts have permitted Congress to do most of what it wants. And there have been some cases that were exceptions. The Violence Against Women Act, that's not really commercial behavior. Guns in schools, that's not really commercial behavior. And so court majorities have sort of said, well, it's got to involve some sort of commerce, but they let it go pretty far. So Gonzalez v. Race was a challenge to the federal drug laws. Someone was convicted under federal law, not state law, of growing marijuana in his backyard. And it's like, I wasn't selling it, I was growing it. But, obviously he had to buy some seeds, and arguably it could affect the sort of drug trade itself, et cetera. I mean, the court sort of let it go. The precedent from the New Deal era, Wickard v. Filburn, had the same basic logic, where a farmer, was using his own crops for his own uses on his own farm, and the federal government said, no, you've got to follow our agricultural regulatory scheme, even though you're not selling it. And the Supreme Court let that go. And so it's a pretty broad rule here. I mean, I do think there are 2 conceptual issues here. One is, of course, just the contractual issue itself. And while Congress, to make no law, abrogating the freedom of contract, has been read much more narrowly than probably it should be by the courts, this is a pretty big infringement on property rights, and so you'll have some litigation premised on that. But the bigger one here is this sort of non-delegation doctrine, and assuming
which John Locke actually espoused.
John Locke was basically among the original exponents of this in terms of writing it down. I mean, he didn't invent the concept. The concept was something that had been fought over the centuries in England, and I go through some of this history in the book. But John Locke wrote, the legislative power exists only to make laws and not to make legislators. And so Locke and Baron de Montesquieu and William Blackstone, who was sort of the great chronicler of the laws of England at the time, the Constitution of the United States was enacted, really developed this principle, saying you cannot delegate the lawmaking power. And this is sort of what I was talking about at the very beginning with the rulemakers, where we've lost some of that. So one question will be just sort of the statutory question. Is this delegation to the CDC, is what the CDC is claiming is within its ambit an accurate reading of what Congress delegated by statute? Then the second question is, even if Congress delegated that broad a power to the Centers for Disease Control, was that constitutional? And while the court has basically not come back with the non-delegation principle since 1935, they basically signed off on the rest of the New Deal in the latter years of the Franklin Roosevelt administration and haven't come back with this principle, notwithstanding, there's some justices on the court who would like to. They have sort of cabined somewhat the ability of the executive branch to sort of make law that really should reside with Congress. And this is a doctrine in constitutional law called the Major Questions Doctrine. And the basic principle here is if it's a big public policy question, Congress needs to resolve it. They probably haven't used this as much as I think they should, but in areas like regulating tobacco, or something of interest to North Carolina, the Food and Drug Administration tried to claim this power, even though Congress had debated it, passed a lot of different bills relating to tobacco, and hadn't expressly said to the FDA, the Food and Drug Administration, you can regulate tobacco as a drug. And the Supreme Court said, no, this is a major question. Congress has discussed this. If this is going to be done, Congress needs to decide it. The executive branch can't decide it for Congress. And we've seen that again in some environmental areas as well, where that major questions doctrines come into place. So I think that could potentially come into play here and create a problem. Again, how long is this going to last? Litigation takes a long time, and so to some degree, it's kind of one of these shots across the bow. I saw news today, Pfizer saying they think if they pass phase 3, they can get the vaccine out by the end of the year. So the executive branch can sometimes play these gambits, and lawyers do it all the time. I've seen it when I was a clerk on the Second Circuit in private practice, where a law firm would take a strategy that probably wasn't going to be a winning strategy, but there's value in delay, and the whole premise here is delay. So it's why the formal rulemaking isn't always where all the power is. It's why I wanted to focus on things like enforcement as well, because the question here isn't necessarily will the CDC ultimately win the lawsuit. It's, well, will a large real estate actor want to cross the executive branch of the federal government? And they may not, even if they're legally in the right.
That's interesting, because let's just play that out a little bit. Let's say someone does decide, okay, I don't think it's a good idea for the CDC or any agency to be essentially suspending or breaking a contract between two parties. So let's take it up the chain. Let's say makes it to the United States Supreme Court. Based on the makeup of the court now, do we have justices who are willing to say, you know what, that you can't delegate that kind of power, you can't go that far? And does that mean that future appointments to the U.S. Supreme Court could be critical to which way this goes?
Absolutely, the appointments will be critical. My guess would be you might get a 5-4 majority saying, with the current Supreme Court saying this is a step too far with delegation. We saw the term before last at the Supreme Court, a 4-4 split. It was really a 5-3 split, but Sam Alito concurred in the result and said, well, if we've got a majority of justices, I may want to reconsider the longstanding way we've treated the non-delegation doctrine. But he didn't want to do it in this case because the case had been argued before Brett Kavanaugh joined the court. And so you had the four, I think it's unfortunate that we often look at justices in partisan terms, and I think it's often unfair. But here we had the 4 Democratic appointed justices saying, no, the non-delegation doctrine, we really don't use this. This is a relic of the past. We jettisoned this in 1937. And then you had Justice Gorsuch, the newest justice, writing a lengthy sort of discussion of the history of the non-delegation doctrine, dating back to the constitutional era and the Anglican, precedents there, including John Locke and British law that underlay it, and saying, this is an important principle. And here's what we do with the major questions doctrine, and here's what we do with constitutional vagueness, and they all sort of fall under this. And I think we ought to bring this doctrine back into the discussion. And so it looked like we had 3 justices, one who said, yes, let's do that, one maybe, and then 4 that said, no, let Congress delegate. And so it's going to be probably a 5-4 case for it to come down. I think Alito would probably sign on board to a certain type of opinion there. And my guess is Brett Kavanaugh would, because Brett Kavanaugh was a big proponent of the major questions doctrine on the D.C. Circuit Court of Appeals.
You know, Jim, you mentioned executive orders, and we have seen former President Obama use them. You mentioned the DACA and the executive order, and then President Trump coming in and trying to do away with that, and then he faced a challenge in court. Does it seem to you, or maybe not, tell me what you think, is the executive the most powerful branch right now?
Oh, I think unambiguously, which was not the case in the early republic. I mean, the early republic, the Congress was clearly the most powerful branch. And so, when Joseph Story, one of the two great early justices on the court, along with John Marshall, wrote his writings on the Constitution, it's pretty clear that Congress has the power here. And then it sort of started going in the other direction. I mean, when Alexander Hamilton wrote about this in the Federalist Papers, the reason why they call the court the least dangerous branch is that it doesn't have the sword and it doesn't have the purse, right? The executive branch has the sword, it has the military, and of course now we have a standing army that is nothing like anything our founders could have conceived. And that's one of the areas I talk about in sort of the introduction to the book, where I think we sort of do have to live with a bit of a bigger government. We're not going to have citizen militias with muskets to defend ourselves against the sort of international threats we face today with modern technology. We have to have some form of standing army, I think, today, even though that was something the founders were very worried about. But the executive branch has the sword. I mean, Congress still has the purse. It's not, the executive branch can move things around a little bit. I mean, Donald Trump tried to do that a little bit with the wall and sort of move some money around. He did that in August, trying to move some money around for COVID relief, because the parties just can't get together in Washington on this. Even in this sort of crisis, I mean, they did quickly. They did a $2 trillion bill in March. Some of it was bad, but they were able to come together and do something. But now I think neither side wants to concede this close to the election. And so we're going to have a lot of businesses potentially going under, and some of those businesses are going under that might be able to thrive, but are being denied the opportunity to do their business based on various state and local actions, and certainly something we've seen here in North Carolina.
Oh, absolutely. And before we get to North Carolina, I wanted to just talk to you about something that I think is really special and very important about your book. And Jim's book, of course, is called The Unelected, How an Unaccountable Elite is Governing America. If you're interested in getting the book, check out the comment section of the John Locke Foundation Facebook page. You'll find the link right there. Jim, you do a really great job, I think, of starting many of your chapters with a real world situation, kind of putting a face on what it is that you are talking about. And one of the stories really struck me, and I remember at the time hearing the story, but you really brought it home, and I'd like you to help our viewers understand about this. If you're a racing fan like I am, you know the name Unser, okay? Well, Bobby Unser found himself in a very strange, dangerous situation at one point, and he really came up against the power of the state. Tell us what happened.
Yeah, so Bobby Unser, of course, won 3 Indianapolis 500s, just a racing champion. You have Al Unser, Bobby Unser. I mean, the Unser family, a big racing family historically. And unsurprisingly, in his retirement, he still likes driving vehicles. And among those are snowmobiles. And so he's got a ranch out west. He drives his snowmobile around in the snow in the winter months. And one day he was going out with a friend of his, who did not have the same experience on snowmobiles, and they were taking snowmobiles out, off his land into sort of federal land, wandering about. What happened was there was a blizzard, and this is not a blizzard that he would have been able to predict necessarily from watching the Weather Channel or something, because it wasn't a storm blowing in. It's one of these sort of ground blizzards where the wind itself is just whipping up the snow to such a high degree that they got caught in this blizzard, got off course, and ultimately got stranded. They ultimately had to abandon their snowmobiles, hike 20 miles, got hypothermia, spent the night. They were lucky to survive this. Afterward, he goes over to the authorities and says, "Oh, I've got to go retrieve my snowmobile." Well, it turns out that in this blizzard, Unser and his friend had gone into an area of protected federal forest that snowmobiles weren't allowed to drive in. Now, Congress hadn't voted on this either, right? I mean, this was based on a regulatory structure with the Forest Service, et cetera, where they just sort of developed, various regulations for how to govern the federal lands. Congress gave them broad authority to regulate the rules. And Unser, his defense was, well, I didn't know. I was stuck in a blizzard. I was under duress. I didn't know this was an area I wasn't able to go. And I was trying to survive in the middle of a blizzard. But notwithstanding that, they said, well, no, you're a criminal. We're going to take you to court. And he argued that as long as he could. He ultimately lost the case because the criminal provision didn't have a criminal intent requirement. So he didn't have to be aware that he was doing anything wrong. He didn't have to have a malicious will. And of course, mistake of law, not knowing that it was illegal is not a defense under our system. So these principles, kind of make sense. Saying mistake of law is not a defense kind of makes sense when we're back on those what we call malum in se crimes, the crimes that we know are bad, the common law crimes, murder, assault, rape, burglary, robbery. I mean, these sorts of crimes, everyone knows they're bad. They're intuitively bad conduct. And of course, you can't say, well, I didn't know it was a crime to hit someone over the head with a 2x4. I mean, you cannot raise that defense under law. But now most of our crimes, not most of the ones that people are in prison for, but most of our crimes are what are called malum prohibitum offenses. And anyone who watched the movie Legally Blonde sort of got a description of this in the creepy criminal law professor's class. But the malum prohibitum offenses are somewhat circularly, they're bad because they're prohibited. People aren't going to necessarily know where the markers are for what the federal forest area is you can and can't go in. And a lot of small business owners get caught up in this where they didn't fill out the right form or they didn't register the right way or didn't put the right sign up. None of these are intuitively wrong conduct, but they can create criminal as well as civil liability. And Unser wanted to fight on that principle, but ultimately he lost. So it was a small fine. He spent a lot more on his lawyers than he had to pay on the fine, but he obviously had enough money to do that and wanted to fight the principle, but lost.
And that is why your description is why the John Locke Foundation and you at the Manhattan Institute have been concentrating so much on overcriminalization. I'm going to ask my colleague Brene to go ahead and post in the comments section here some of John Gouzet's work on overcriminalization in North Carolina. In fact, she's already done that. She's ahead of me, Jim, here, so on the conversation. Speaking of North Carolina, let's take advantage of your legal background and the fact that you are a North Carolina resident. You live in New Bern, even though you're with the Manhattan Institute, which is one of the most renowned national think tanks in the United States. Okay, so tell us what you think of the COVID situation and the use of the emergency powers by Governor Roy Cooper and Dr. Mandy Cohen, who is the Secretary of Health and Human Services.
Yeah, well, I mean, I want to sort of separate out a little bit the policy response and then the sort of legalities of it, right? I mean, I am not an epidemiologist or a doctor, so I don't feel perfectly qualified to say this is what the right rules should or shouldn't be. But I do feel quite confident in saying that the use of emergency powers for months by the governor, in my mind, in a clear end run around the statutory delegation to the governor, is deeply, deeply troubling. So North Carolina, as every state does, delegates certain emergency powers to the executive. This is very important. So here, when we're near the coast, where I live, if a hurricane's bearing down on us, you don't want to have to get the legislators to Raleigh. We have a citizen legislature still here. They're not a full-time Congress. So very important to act quickly in emergency situations. If we were under a terrorist attack or what have you, we need to delegate some emergency authority to the executive in those situations. But that can't be an open-ended ability for the governor and only the governor to sort of broadly regulate the state. And the breadth of authority here, and again, Roy Cooper is not unique in this among governors around the country, although I think he's one of the more extreme exemplars of using emergency power. But when the breadth of this is basically telling people you can't open your business, you can't leave your home. Saying you can't leave your home in a hurricane is the sort of power we want to give the governor. And there's a longstanding history of certain types of quarantines. I mean, I go through some of this in the epilogue of my book, talking about the COVID situation, going back to the yellow fever epidemic of 1793, where George Washington moved the cabinet out of Philadelphia. Alexander Hamilton caught yellow fever, and Baltimore and New York said people from Philadelphia can't come here. It was carried by mosquitoes, not people. I'm not sure that did much, but they didn't know exactly what was causing this disease. So there is the case for certain extraordinary powers, but the actual delegation here, I think, probably was constitutional from the General Assembly, in the sense that it clearly was intended to be a more short-term fix, and for large, major sorts of moves, the sort of business shutdowns that the governor has chosen to do here. The governor is supposed to have the consent of a majority of the Council of State. So you're not just delegating everything to a king. And this is the sort of core principle of the non-delegation doctrine. I mean, I talk about this in the book after I talk about John Locke. I mean, John Locke wasn't inventing these principles whole cloth. This is what they were fighting about in England in the run-up to the English Civil War. So Charles I, after Sir Edward Coke, the great sort of legal scholar and parliamentarian, passed the Petition of Right, sort of circumscribing royal power, Charles I dissolved Parliament and ruled without it in the period called the Personal Rule for 11 years. And later, this was called the 11 Years Tyranny for a reason. Now Roy Cooper's not going to be in office for 11 years, but we're going on now several months where, without the consent of the Council of State, the governor is denying the most basic sort of right to open your business, very fundamental freedoms of individuals. And this isn't a situation where, I want to emphasize, we're quarantining someone who's tested positive for COVID. I mean, the government has pretty broad authority to do that. If someone tests positive of a communicable disease, to quarantine them is a long-standing exception to our general liberty principles that have been well understood. I mean, it's not as if someone with a communicable disease can just go out of the house if that's easily communicated. If the government wants to cabin that sort of movement, that would be one thing. But here we have people who haven't tested positive for COVID, and they're just saying, well, you can't open your business because of a general risk. The constitutionality of that, we've given the government enough authority, and states obviously have broader authority than the federal government here. The federal government is one of, at least in principle, limited delegated powers, where states have broad public police power. But clearly we shouldn't be delegating this to the governor, and it's really disheartening to me to see it. I don't know, which way the polls go. I don't know what the public thinks. Roy Cooper's poll numbers look pretty good, so maybe people are fine with this. But it really, really worries me. And so I do hope that after we get a vaccine, after things go back to normal, that the General Assembly will much more clearly mark down the limits of this executive emergency power, because I do think it's been abused.
And Jim, in our remaining moments with you, give us a sense of what the future is. What should we do? Those of us who believe that there's too much power that's been delegated at the federal level. What are the next steps to try to rein that in? Are we in a situation where we could even rein it in?
Well, we're not going to get back. I mean, I say this, and one of my early reviewers said, well, he's not very radical in his solutions. I mean, I think some of these suggestions are potentially radical, but what we're not going to do is get back to a $10 million federal government. We're not going to get back to a 1788 government. But I do think we can push in directions. I think the courts can do that, but I also think that the legislature can do it, and that at the federal level would be Congress, and of course at the state level, the General Assembly can come in there and do things. So to take a state level example, it's a very complicated question. I can't really answer in 3 minutes the totality of my ideas, and I'm going to be putting out 4 different reports over the next year and a half, sort of fleshing out these ideas that I outline in chapter 14 of the book, with more specificity for policymakers, because I didn't want to bore people with 100 pages of policy wonk detail, right? But in North Carolina, you could sit there and say, well, we're delegating some of this authority to these agencies, but before it's criminal, you've got to come back and get a vote from the legislature. I mean, this is something Congress could do. It's something the General Assembly of North Carolina could do. Or you could say, we're going to sunset these. We're going to delegate some authority. It's got to come back to us. And if we don't affirmatively vote on it, then it's going to sunset. So you only get a temporary move through executive action and things. I think the more you can do that and prevent just sort of the permanent layering of the administrative state, the better. And a lot of these rules, the procedural rules, you know, when it comes to the litigators, we're not going to get back to what lawyers call caveat emptor, let the buyer beware. It's too complicated for me to know everything about my computer, and if it blows up and takes my arm off, the fact that I bought the computer, you know, society's not going to go that far back. But there are a lot of things we can do to prevent these sort of shakedown games with class action rules, with pleading standards, with discovery rules, with the fee shifting between lawyers. There's a lot of things we could do to make it so that we're actually litigating real injuries and not ones that are concocted by the attorneys as a shakedown, like the disability suit against Kathy Reese McNeil that led her to abandon a noble effort to renovate a historic property.
It is an incredible subject, and by the way, I'll just let people know that regulatory reform here in North Carolina, our own John Sanders has been writing for several years about efforts to do that. We've made some progress here in North Carolina thanks to the Republican-led General Assembly, and I'll ask Brene to go ahead and provide a link for you. If you're interested in taking a look at some of that progress, we can show you. It's one of the areas that we focus on here at the John Locke Foundation with our research team. And happy to say that there has been some progress at the state level here, thanks to the leadership of the General Assembly. Jim, the book is really fascinating, and we wish you the very best with it. Again, it's called The Unelected: How an Unaccountable Elite is Governing America. It's great, and yeah, I would say it's easy to read. That doesn't mean that it's simplistic. It's very meaty information, and I also really do appreciate that you put a face on a lot of this with examples of people who have come into contact with the administrative state and have not done well, and in at least one case that you write about, a tragic ending to someone who was in a very difficult situation. Jim, thank you so much. We appreciate your time. Jim Copeland is with the Manhattan Institute, and please do check out his latest book, The Unelected. Thank you, Jim. Appreciate you joining us.